Well, good afternoon, and we appreciate everybody attending today's conversation it's our case law update with Luis Sarmiento. My name is Dave Zapponi. I'm the CEO of ECHO, otherwise known as the Educational Council of Homeowners. Thank you so much for coming and participating in today's case law update. ECHO is a statewide nonprofit association established to support HOA board members and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and connections. For today's event, we have a few housekeeping items. These are now presented on your screen. In addition, slides were sent to all registered attendees prior to today's webinar. Please take a moment to review our housekeeping items. The chat icon is to be used to report technical issues and to communicate directly with other participants in the webinar or the speakers. You can place your questions in the Q&A feature as you like. I will try to answer some of those questions during the presentation, or we may answer all questions during the Q&A period at the end of the webinar. And I'm not an attorney, so I will answer those as a non-attorney. So there you go. Questions about specific situations are better asked of the attorney serving your association or another appropriate industry professional familiar with your situation. Now, let me direct your attention to our disclaimer. It's on your monitor. None of what is said during this seminar shall be construed as specific legal or expert advice from the speaker, sponsors, or ECHO. If you wish specific advice, we encourage you to contact your attorney or another suitable expert. The information we provide during this webinar is educational in nature and should not be relied upon for specific decision-making purposes. So thank you so much for listening to that. We appreciate it. This event, as well as all of our events, are made possible by the contributions of our generous professional sponsors. Class fees today help support the development costs of our educational programs and defray some of our production expenses. Thank you very much. Please join me in thanking our sponsors. Our registration sponsors are Associa and Levy Erlinger and Company LLP CPAs. Please support all ECHO professional members and especially our sponsors. They make our educational programming possible at little or no cost to you. And now a bit about our speaker today. Luis Sarmiento Jr., Esquire, is an associate at Shear Smith and Kenny LLP, where he advises homeowner associations and other mutual benefit corporations, businesses, and individuals on common interest development, real estate, corporate, and general business matters. Luis advises homeowners association boards and officers on matters including governance, development, and enforcement. Luis is also our newest member on the board of directors of ECHO, and we appreciate his time that he's spending and volunteering to help us with the ECHO programming. So thank you so much, Luis. We appreciate you coming, and go ahead and take it away.
My pleasure. Thank you, Dave. Welcome all. Again, I'm Luis. Today we are gonna like to take it to the roadmap for today. Today we're gonna go over 3 cases and 3 pertinent laws that affect CIDs. First is going to be Woolard versus Regent Real Estate Services. This case goes into question of responsibility for an HOA and management company regarding a neighbor-to-neighbor physical altercation, and we'll get into the details a little bit. Next case is going to be 11640 Woodbridge Condo Association v. Farmers. This is interesting one, dealing with an all-risk property insurance coverage for an HOA building where 2 incidences occurred during the roof repair for a 31-unit condo building. So we'll get into the details into that. And then Nabat Mama, forgive me if that's incorrect, versus Ross Morgan and Company Incorporated. This is one where we've got a occupant who received fines for CC&R's violations and questions related to the Fair Debt Collection Practices Act. 3 pertinent laws that became effective as of January 1st, 2025 that we'll be digging into as well. We've got AB 2159 dealing with online voting, AB 2460 dealing with lowering the quorum for member elections, and finally SB 900 dealing with utility interruptions. So our first case, Woolard v. Regent. The issue here is whether the HOA or management company owes a duty of care to intervene in a dispute involving tenants. This was dealing with the complaint by plaintiffs for indemnification, apportionment of fault, declaratory relief, and negligence alleged against the HOA and management company. So let's discuss the parties. 2 Erics here, so I'll try to keep them consistent. So it's Eric Smith and Stacy Thorne. These were residents of the HOA. Smith is one of the gentlemen involved in the fight. We've also got Woolard and Hall. They also were residents. Woolard was another gentleman in the fight. We've also got Greenhouse Community Association. This is a California HOA, and we've got Regent Real Estate Services. Regent does business as Regent Association Services, and it provides common interest development management services. So here, a little bit about the background. On December 27th, 2019, Smith and Thorne were in their home. Their next door neighbors, Woolard and Hall, started an argument with Smith and Thorne, according to the complaint, and that argument escalated into a physical altercation. Smith and Thorne alleged that there was punching, kicking, an assault with a flashlight, and that Smith was stabbed, allegedly resulting in severe mental, physical, and emotional injuries. So in response, Woolard and Hall, they filed their own suit by filing a cross complaint against the HOA and management company, essentially saying, no, it wasn't us that had at fault. It was the HOA and management that's to blame. So according to Woolard and Hall, the physical altercation was the result of a long-standing harassment by multiple neighbors. As to Regent and Greenhouse, the HOA, Woolard and Hall pleaded causes of action for indemnification, apportionment of fault, general negligence, and interference with economic relations. They sought general and punitive damages. At the initial phase, most of Woolard and Hall's causes of actions were dismissed, but most notably, the negligence claim was not dismissed. So a little more background. In April 2023, Regent and Greenhouse filed a joint motion for summary judgment, or alternatively, summary adjudication on Hall and Woolard's remaining claims. Again, this is just to try to knock out those claims and try to get a decision without a trial. Regent contended that Regent was responsible. Hall and Woolard contended that Regent was responsible in all its actions as to Hall and Woolard, and that it did not owe a duty to contact police or in the dispute with the plaintiffs. And in response, Greenhouse argued that Hall and Woolard cannot prevail on their claims as Greenhouse, the association, was reasonable in all its actions as to Hall and Woolard, and that they did not owe a duty of care to contact the police or intervene in any way in the dispute with the plaintiffs. So the court orders accepted the Regent and Greenhouse contention that there had no duty to intervene in the neighbor dispute or to prevent the physical altercation between Hall and Woolard on the one side and Smith and Thorne on the other. The duty, duty is a question of law, and Woolard and Hall had not established a legal duty to intervene as in the dispute between the residents. So the court concluded that the claims for indemnification, apportionment of fault, and debt relief were not legally recognizable claims, and that there were no tribal issues of material fact. So here we are. We're in the Court of Appeals. The Court of Appeals looks at this since there was summary judgment at the trial court level. They determined that well, first they established that summary judgment is appropriate if all the papers submitted show that there is no tribal issue of material fact and that the moving party is entitled to judgment as a matter of law. And to prevail in this motion, the defendant must demonstrate that the plaintiff's cause of action or actions have no merit. And this can be satisfied by showing that either one or more of the elements of the cause of action cannot be established, or that the complete defense exists. So here, using that same procedure, the Court of Appeal looks to the admissible evidence and tries to determine whether or not the judgment was in favor of that party that filed the motion, and then afterwards it looks to the other party's response papers to determine whether or not the opposing party has demonstrated the existence of a tribal material fact at issue. So since the negligence claim was all that existed after the others had been knocked out earlier, the negligence claims elements are important to discuss. It's the duty, breach, causation, and damages. Duty may be imposed by law. It may be assumed by the defendant, or it may exist by virtue of a special relationship. And the existence of a legal duty depends upon the foreseeability of risk and a weighing of policy considerations for and against the imposition of liability. In their briefs, Woolard and Hall failed to identify any duty that Regent or the HOA had. In the opposition to the motion for summary judgment, Woolard and Hollard actually specifically disclaimed any notion that they were seeking to impose a duty on the management company or the HOA to contact or call the police or make any call on their behalf regarding the dispute. So the court noted that there was an issue that Woolard and Hall were tenants, and not that, and as opposed to being owners or members of the association. So there's a even further limited relationship between the HOA and a tenant of a unit. And as tenants, they had no legal standing to maintain a complaint against the HOA, or that the HOA failed to adequately enforce its own governing documents. So as a result, the HOA's duties to the tenants are much more limited than they would be if they were actually owners. So in the Court of Appeals concluded that there simply was no law to support the tenants' contentions that Regent or the HOA had some unspecified duty to do something to prevent what turned out to be allegedly violent dispute, posing a duty on homeowners associations or their managing agents to intervene or attempt to resolve disputes between homeowners or their tenants would place them in an untenable burden on these entities, the court said. As we all know, the boards are all volunteers and associations are run by those volunteers, and court noted that they already have enough authority and responsibility. And parenthetical, they actually said that the volunteers arguably have too much responsibility. The associations do not have police powers or subpoena powers. They cannot compel owners, much less tenants of owners, to sit down and work out their differences. They cannot adjudicate differences except in limited context of violations of the association's governing documents. There was evidence here that the association properly responded to complaints about violations of governing documents that it received, but imposing a duty under these facts would leave this association and associations generally liable for an outcome of such disputes without the tools to actually prevent them. This would leave homeowners holding the bag when special assessments are needed to pay judgments or attorney's fees. And the court found that Regent and Greenhouse played no part in the physical altercation at issue and should never have been dragged into this dispute. So in short, no duty equals no negligence. Implications, I'm reluctant to apply any general application or rule here. Obviously, we want homeowners and tenants to feel comfortable and safe in their homes. I'm not going to try to glean some general guidelines or say what a community manager or HOA should do or not do when a neighbor-to-neighbor dispute arises. Well, it's certainly good to see that this decision fell the way it did, because the alternative, especially if we were to set precedent, could have set up a difficult position for boards, HOAs, and managers. But certainly investigate and do what you can. But under this case, there was no obligation or duty for the association or the management company to prevent or otherwise intervene in the dispute. The next case is 1160 Woodbridge Condominium HOA versus Farmers. In this case, we're going to be exploring the liability for an insurer in connection with an all risk or all perils condominium insurance policy for water damage that occurred during the re-roofing when rainstorms penetrated a partially constructed roof. Parties here are 1164 Woodbridge. This is a 31-unit condo building in LA County. And on the other side, we've got Farmers. It's the defendant in this action, and it was the insurer for the HOA. So a little background. In 2021, while the HOA's building was being re-roofed, the roofing company began the job on or about September 29th, and over the next 5 days removed approximately 80% of the roof membrane. The roofer intended to replace those portions of the plywood sheets that had showed evidence of dry rot and then install new layers of the new roofing membrane. However, on October 4th, after the roof membrane was removed, there was a rainstorm that damaged the exposed insulation and plywood. And as a result, water entered about half of the 31 condo units. And then because of the damage caused by the rain, the roofer had to remove and replace about 80% of the insulation and plywood. He then added a layer of base paper, done some other temporary actions to cover the entire roof with tarps before the next rain was expected. Unfortunately, a second heavy rainstorm was on or about October 25th. And then that rainstorm blew off the tarps, penetrated the exposed felt layer, and as a result, water entered into all of the 31 condo units, causing significant damage. The HOA was insured. It had a condo townhome premier policy underwritten by Farmers for that time period. Under that policy, Farmers agreed to pay for direct physical loss of or damage to covered property at the HOA's premises caused by or resulting from any covered cause loss. And the policy defined the relevant terms as follows. So covered property includes, quote, the building, the structure, the building and structure described in the declarations, including completed additions, personal property owned by the HOA, and if not covered by other insurance, additions under construction, alterations, and repairs to the building structure. Covered property excludes, among other things, physical property owned by or used by or in the care or custody or control of a unit owner. Covered causes of loss are another defined term, and it includes, it was defined to include risk or direct physical loss, which is also itself a defined term as insurance policies can be, and I'm sure you've seen these, but those risks of direct physical loss would be covered costs unless the loss is excluded. So there was two coverage exclusions that were relevant to our analysis here. It is the water damage exclusion and the faulty workmanship exclusion. So the HOA made an insurance claim, and farmers denied coverage relying on the water damage exclusion, claiming that the partially remaining elements of a roof was not a roof, and it also relied upon the faulty workmanship exclusion, claiming that the HOA's roofer was negligent. So in response, the HOA filed a lawsuit against farmer and against the roofer in January 2022. As to the roofer, the HOA alleged that the roofer removed the entire top layer of the building's roof all the way down to the plywood decking that served as the roof's foundation. And because the roof was not fully protected from the elements, when the storm hit on October 4th and 25th, the roof was damaged and ultimately resulting in water intrusion to the walls and its interior. And specifically, many of the complex 31 units suffered collapsing ceilings, waterlogged walls, forcing the residents to move out. And the cost of remediation repair was estimated at more than $3.5 million. As against farmers, the HOA asserted causes of action for breach of contract, breach of implied covenant of good faith and fair dealing. Specifically, the HOA alleged that the water exclusion policy did not apply because the HOA sustained damage first to its roof and walls, through which the rain entered, and then the HOA alleged that the faulty workmanship exclusion did not apply because courts have interpreted to not apply to the faulty processes employed by the contractor, and because the building first sustained damage to the roof before it entered the building. So at trial court, in February 2023, farmers filed a motion for summary judgment. Here we go again, summary judgment, asking the court to rule in its favor without a full trial, issued solely on the merits of the case. And again, summary judgment is proper if the papers submitted show that there was no triable issue as to any material fact and that the moving party is entitled to prevail on the cause of action as a matter of law. So the trial court granted the motion for summary judgment, concluding that the policy did not cover the HOA's losses because both water damage exclusion and the faulty workmanship exclusion applied. The trial court entered judgment on July 13th, 2023, and the HOA appealed. So at the Court of Appeal level, they got into it. So they discussed that there are two general categories of first-party property insurance. There's the named perils or specific perils policies that provide coverage only to specific risks enumerated in the policy. Think fire insurance or earthquake insurance. So those are very specific items. And then the other is all risk policies for all perils, and that provide coverage for all risk unless the specified risk is excluded. So here at the decision, the Court of Appeal concluded that the rain damage resulting from the roof repairs were covered under the policy, and farmers did not demonstrate that it was entitled to summary judgment under the faulty workmanship exclusion. The court went into a pretty lengthy analysis of cases and also ultimately decided that they could not say that there was not a roof. Certainly it was temporary in nature, but there were enough elements that covered the top of the building to state that it could conceivably be a roof. And this case, they actually pointed into the ambiguity of the policy, and public policy indicates that to the extent there is ambiguity, especially in these insurance policies, that it's going to be construed in favor of the insured, the HOA here. So that certainly worked in favor for the HOA. And the implications for the CIDs for common interest developments, serves as a reminder to work with counsel while tendering claims and when claims are denied. Unfortunately, it sometimes requires HOA's counsel or even insurance coverage counsel to get an insurer to fulfill its obligations under a policy. In my experience, it does sometimes require hiring an attorney that specializes in insurance coverage to advise a board and to even advise me as outside general counsel to discuss what a policy does or does not include, and by extension, what the insurer is required to cover. Next case is gonna butcher this again, my apologies. Nabat Mama v. Ross Morgan and Company Incorporated. So if you attended our last case law update in November 2024, you might recall that case Doscox v. ALS Lien Services. That also involved the Fair Debt Collection Practices Act. The practical takeaway there in that case was that association managers and collection companies must follow the highly technical assessment collection process. So here in this case, one of the allegations is that Ross Morgan did not follow those highly technical assessment collection processes, which we're going to jump into now. So parties is Jeffrey. He's the plaintiff, and he is the resident of a condo unit within the Shenandoah Villas Homeowners Association, which is a 15-unit association. So while the plaintiff resides in this unit, he's not the legal owner of that unit. The legal owner of this unit is a family trust, which seems to be related, or at least one or two of the people who are involved in that family trust share the same last name as a plaintiff. But again, family trust is the legal owner. Ross Morgan is the defendant and is an association management company. Ross Morgan's president is listed as the HOA's manager. And according to the plaintiff's complaint, Ross Morgan also acted as the debt collector for the HOA in this matter. A little bit about the background. On March 25th, 2024, the HOA held a meeting where fines and penalties were imposed against the plaintiff for violating the HOA, totaling more than $106,000. The fines were allegedly for violations of the governing documents, but the plaintiff alleged that the HOA failed to provide proper notice of the meeting to the family trust, who were the legal owner, or which was the legal owner of the property. And then on the following day, the HOA sent a notice of decision for the hearing to the plaintiff only, not the legal owners. And that the notice notified him of the fines and threatened that if the unpaid fines, and threatened that if unpaid, the fines would be collected via monetary judgment, imposition of liens, and foreclosure proceedings. So again, a little more about background. The plaintiff alleged that Ross Morgan wrongfully billed him and that the family trust for those fines, wrongfully billed him and his own trust, not the family trust which owned the property, despite plaintiff having no legal ownership interest in the property and that the rightful owner had not received notice of the meeting. Additionally, the plaintiff alleged that Ross Morgan acted as a debt collector for the HOA. They have continued to invoice and threaten to collect fines against plaintiff for which he is not liable, misrepresenting the nature and status of the debt. It was alleged that Ross Morgan knew or had reason to know that plaintiff is not the proper party responsible for these debts, which would be a violation of the Fair Debt Collection Practices Act. So in the lawsuit, plaintiff alleged 8 violations of the FDCPA. 1, using false, deceptive, or misleading representations as a means of connection with the collection of debt. 2, falsely representing the character, amount, or legal status of any debt. 3, threatening to take any action that cannot legally be taken or is not intended to be taken. 4, using any false representation or deceptive means to collect or attempt to collect a debt or attempt to obtain information concerning that consumer. 5, using any unfair, unconscionable means to collect or attempt to collect any debt. 6, taking or threatening to take any non-judicial action to effect a disposition or disablement of property. If there was no right to possession of the property claimed as collateral, if there was no present intention to take possession of the property, or if the property is exempt by law from such disposition. 7, failing to adequately disclose the right of verification, and 8, engaging in conduct that not natural consequences of which is to harass, oppress, or abuse any person in connection with the collection of debt. So the plaintiff files a complaint, which formally begins the process in trial court. The defendant's first responsive document was a motion to dismiss the claim. So we're going to go over a little high-level understanding into the applicable federal rule of civil procedure and the controlling Supreme Court case law. The federal rules allow an attack on pleadings for failure to state a claim upon which relief can be granted. And in order to survive that motion, the complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. A claim has facial plausibility, or it's plausible on its face, when a plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct that is alleged. Dismissal under this rule is proper when the complainant when the complaint either 1, lacks a cognizable legal theory, or 2, fails to allege sufficient facts to support a cognizable legal theory. The determination of whether the complaint satisfies the plausibility standard is context specific. It requires a reviewing that the reviewing court draws on its judicial experience and common sense. So generally, a court must accept the factual allegations in the pleading as true and view them in the light most favorable to the plaintiff. So let's discuss that motion to dismiss. To state a claim under the FDCPA, the plaintiff must allege that 1, he is a consumer under the meaning of the act, 2, that the debt arises out of the transaction that was entered into for personal purposes, 3, the defendant is a debt collector, 4, that the defendant violated one of the provisions of the FDCPA. And the court here bases opinion on whether or not the dispute involves a debt under the FDCPA. The act defines a debt as a obligation. I'm sorry. And if we can go on the next slide. And one more. Debt is any obligation or alleged obligation of a consumer to pay money arising out of a transaction in which that money, property, insurance, or services which are the subject of the transaction are primarily for personal, family, or household purposes, whether or not such obligation has been reduced to a judgment. So the defendant argued that the fines which the HOA were seeking to collect from plaintiff did not fall under the Act's definition of a debt. Courts in this circuit have recognized that an ongoing obligation to pay assessments to HOAs are a consumer debt under the FDCPA because the promise to pay occurs when the homeowner purchases the property, and then therefore it arises out of a consumer real estate transaction. and the Ninth Circuit Court of Appeals, the Federal District Court of Appeals, or Federal Courts of Appeals, which covers California and the West Coast and Hawaii, has also endorsed this view. But the court determined that because HOA fines are not obligations to pay arising out of these transactions, other courts have found that these fines are not a debt for purposes of the act. So again, no debt, no claim. Court granted the defendant's motion to dismiss the complaint. So we've got an appeal. The plaintiff appealed on April 29th, 2025, a little over a month ago. So I'll certainly be tracking this and covering it in future case law updates, as I imagine this would have an impact on common interest developments in California. So implications. Association managers and collection companies certainly must follow the highly technical assessment collection policies. Again, whether or not these fall under the Fair Debt Collection Practices Act. And while the trial court dismissed those claims under this particular fact pattern, it does not negate the fact that association assessments, fines, and fees each have technical requirements related to notices, hearings, liens, collections, and enforcement. All right, next we are going to go into select changes in statute. These have taken effect at the beginning of this year and currently are in effect now. You'll see it's electronic secret ballot voting, reduced quorum for directors' elections, and associations' responsibilities for utility systems. First, we have AB 2159. This bill, this law now, has authorized associations to adopt an election operating rule that would allow that association to utilize an inspector or inspectors of elections to conduct an election by electronic secret ballot, except in certain circumstances and notwithstanding the association's governing documents. This law would require that rule that's adopted to permit a member to change their preferred method of voting no later than 90 days before an election. And this law also requires the association to deliver individual notice to each member that includes certain information about voting by electronic secret ballot. It clarifies that if an electronic secret ballot is used, it's going to be effective when transmitted and it is irrevocable. Next, we've got AB 2460. Again, if you attended the case law later last year, you might recall that there was a new law that went into effect January 1st, 2024. This bill cleans up and addresses the ambiguity in the earlier law. It clarifies processes through which the association will adjourn a meeting into a preceding date at least 20 days afterwards, and at which time that quorum requirement would be 20%. This only applies if the association's governing documents requires a quorum and only for director elections. So obviously that means that the process would not apply for other member voting. It would apply if a quorum is not required for director elections, and it would not apply if quorum is required by governing documents, but the quorum is less than 20%. Got SB 900. So this bill provides that unless otherwise provided in the declarations, the HOA is responsible for repairs and replacements for matters relating to interruption of services. Think gas, heat, water, electrical, that begin in the common area, even if that service extends into the separate interest. It clarifies that it does not apply if there is a state of emergency declared. This law requires HOAs to commence repairs or replacements to interrupted utility services within 14 days. It also provides that if a vote does not take place within this 14-day period and there are insufficient reserve funds available, the HOA may obtain financing to pay for the repair costs without a vote of the membership. And it provides that this vote may take place by electronic means, such as email. This law also provides that if substantial repairs are needed to a utility service of the CID, a representative of the utility shall address the HOA in person to present a description of the problem, suggested solutions, and expected timelines. And finally, this law expands assessment increases necessary for emergency situations to include repairs or maintenance of the CID or any part of it for which the HOA is responsible, where threat to personal health is discovered on the property. So one example of how this would play out is a gas leak. In particular, there was a gas leak in a 200-unit condo building in Orange County that was discovered, and citing safety reasons, the local gas company shut off service. As a result, residents had no access to hot water or cooking or laundry facilities for months. The gas company claimed that the gas lines were owned by the condominium building, and therefore the HOA and the management company were responsible for fixing the problem. There were certainly concerns that the building would be red tagged by local building officials because of health and safety code violations and the fact that hundreds of residents could be displaced. So after weeks of disputes on who was responsible, where the leak originated, the HOA took out loans to address the costly emergency assessment and then splitting the costs among all of the HOA members. This bill was, or now law, it was written as a bill and was written to attempt to prevent a situation like this one in Orange County from happening again, where residents lived in substandard housing for months. And so it'll be interesting to see how that one plays out for sure.
Okay.
And we are now taking it to questions, Q&As.
Let's go ahead and start the Q&A session. And thank you, Louis, for those updates. Not a lot has happened since the last time we had our presentation, so appreciate that. Actually, I kind of appreciate it more than you know, that we don't have to deal with this as much. So if you wouldn't mind taking a look at the questions, the Q&A feature, pull it up on your screens, everyone.
Sure.
And there is a little thumbs up icon on the bottom. If you could vote for your favorite questions, and we'll go ahead and get through them. I think we can probably get through most of these. We finished really early, so we'll have time to have a good conversation here. And just go ahead and vote. That'll be helpful. If you put a comment or a question in the chat feature, please move it over to the Q&A feature so that we can look at it. And then for you, Louis, if you go up to the upper right corner, it says most recent. If you could click on that little caret down, and it'll say most upvotes, and you'll move it to the most upvotes. And we'll go ahead and start answering some of these questions. Let's go to the top here. 1 second. Okay. Jerry asks, there seems to be a conflict between federal law and the California HOA law. If a confidential email is sent to the property manager, are they required to forward it to the board of directors? The emails clearly stated the confidentiality of the email and named ECPA, I don't know what that is, a potential violations. Which are
Electronic Communications Privacy Act. That is certainly beyond the scope of this communication and this discussion. Certainly sounds like there's a particular question or more distinct situation here. So sorry, Jerry, I cannot get into that analysis on
Yeah,
it.
so as a non-attorney, I'll answer a little bit more, have a little more latitude. The generally speaking, the there is a contract, an agency contract with the board of directors, and there is as a contract with the board of directors, there should be no expectation of privacy, even if you put confidential on the top of it, because they are in essence working for the board of directors. And so if you have a complaint or an issue relevant to the property itself, I would feel really nervous about expecting um, confidentiality, even if you wrote it. So that's the way I would look at it as a layperson and a board member. So you can take that one any way you want. So there you go. All right. Brad Bowles, in the Woodbridge versus Farmers,
Sure.
where is the roofer's insurance? How did the roofer's insurance coverage play into the case? Do you know how whatever happened?
That case, it, the appeal decision just brought it back down to trial court. So the roofer was involved as a co-defendant, and Farmers was involved in a co-defendant. The trial court knocked out the claim because it said that there was no facts, or there were insufficient facts to actually state a claim. And as under motion for summary judgment, that the court should dismiss the claim. And since the trial court said, yes, we're going to be dismissing the claim, it didn't get into the roofer at all. So this Court of Appeals reversal of the trial court's dismissal kind of picks it back up, and they kind of start all over again. But certainly there was a claim against the roofer, and I would presume the roofer made a claim against their own insurance to say, hey, we've been sued.
Okay. So we have our next question, and that is Jackie Brodsky. Hi, Jackie. Nice to see you again or hear from you again. And here's your question. What is the best response to an HOA owner who complains about every neighbor and vendor, gardener, etc.? Again, from my perspective, it's like mind your own business, right? But okay, so that aside, do you have any pearls of wisdom for her, Lewis? I see Carol did respond and says depends. That makes sense.
That's my favorite answer as an attorney. Depends.
Okay.
But seriously, that I think the board should take and review every response. Certainly, there is an obligation that the directors have and duty to investigate. So if it seems like there's any grain of a real concern or something that the board needs to act on, then the board should act accordingly. But for the time being, they should receive it and consider it. But yeah, consider it. And in its consideration, it can consider to do nothing or to determine to do nothing. But it should take it into consideration and certainly decide how it wants to proceed.
Yeah, well, I think the other thing you could do is just sit down with that neighbor, and this may not work. I get it. I understand that. But and talk with them and let them know, if you're always saying there's the sky is falling, you know, and it eventually does fall, but everybody starts getting just a little bit tired of hearing the complaints, and don't respond the way they probably should. And you might ask them to prioritize and make sure that whatever the priorities there. The other thing, it's another good tactic is to make sure that it's written. Tell them that, hey,
Right.
look, we'll take complaints, but they have to be written, and we do
Right.
look at these and we will consider them. So that's the other thing to do. One other thing that I just wrote an article about the elephants in the room and how to eat them. The board sometimes has an issue working on minutia, and if you're getting a lot of complaints that are minutia that really are at the very task-oriented level, that's really property manager can help you with that and keep those away from the board and have them go through the property manager. That can work, depends on your situation. This is all, Carol is right. It's all dependent. So that's really important. Charles here put up an answer as well. I'm going to read it really quick. Mr. Kaufman, if you had a harassment policy, you can require the neighbor to cease bothering vendors and others or conduct a call to hearing and fine as both harassing and being a nuisance. So yeah, you can put in place policies as well to help direct how these issues are handled, and that's a really good suggestion. As to you can take it to that extent if this is a really significant problem. So anyhow, those are some good answers. And I'm going to say, Charles, reminded me that we do have our board members club meetings monthly, and this is a really great question for the other board members that are in the club, and you can sign up as an Echo member. All right, anonymous attendee. Let's go to the next one here, Connor. And so the anonymous attendee, let's see. Oh no, this is from Carol Moore. So,
Well, actually, if we can go to the anonymous attendee. So
okay.
the question was, why wasn't the roofer's carrier included in the initials?
Ah, I see. Yeah.
That the carrier, the HOA has no standing as to any claim against the roofer's carrier unless the roofer's carrier or unless the roofer's policy listed the HOA as an additional insured. The reason I wanted to go back to that is because in disputes with vendors or in other issues where insurance is involved, it's also it's important to remember that insurance is there as for the benefit of the insured. So while the roofer's carrier and their policy benefits the roofer, the HOA had no claim to say, hey, this is something that you should cover, roofer. The reason why Farmers was involved as a defendant was because Farmers was the carrier for the HOA. So whether or not the roofer has insurance or any amount of assets put aside, the claim that the HOA have is against the roofer as to the roofer's work. And certainly there's a claim against insurance for failure to cover the policy or pay out under the policy. But when it comes to the roofer, the HOA wouldn't make a claim against the roofer's carrier. Again, the carrier is just is a purse, a means of paying the claim against the roofer. So the claim should be and was properly made against the roofer.
Okay. Sounds good. Thank you for that.
Yes.
Sorry, I missed the question. Okay, Carol Moore. Hi, Carol. How are you? Should the HOA have performed a title search prior to the action?
Absolutely. So when there are notices for fines, for their notices going out for delinquent assessments, when there are reimbursement assessments, there should be a title search just to confirm who actually is the owner. I know sometimes in the members lists or other voters lists, other lists that the associations have, sometimes it's created out of convenience and it'll say, well, this is our contact person. And many times that contact person for a unit is going to be the tenant. So if it's a tenant, it's a rented unit, that list, like it would have incorrect people if it's listing the people who are actually occupying the units as opposed to the people who actually own the unit. So, I think either managers and associations be diligent about their list to say, well, who is our contact person for each unit and who occupies each unit? Or one way to make sure that it's being done each time is that the property title is searched to confirm exactly who is the legal owner of a unit.
Okay, great answer. Denise is Chisholm. So Denise has got 4 votes. I appreciate you using the vote feature. That does help a lot. You may need to refresh your screen there, Lewis, to
Sure.
make sure you
Sorry.
get them in the front. Okay. Would late fees and interest on dues be considered a debt?
I don't know. So I guess it depends on whether you're asking if there were late fees on an assessment, but the underlying assessment was paid. And then you're saying that there's action or collection that's involved for those late fees alone and the interest alone, and not based on the underlying assessment. I would have to look at the definition of debt again to see if that would be part of it, since this is more of a outgrowth, or this is a uh, result of an assessment, which the assessment itself is considered a debt, but this is follow up, or something that followed after the one item that actually is debt. So I don't know off the top of my head, but certainly steps should be followed in this highly technical process to ensure that the process is being followed, and that the debt collectors are not taking any steps that are in violation of the law.
Okay, so there you go. Let's go to John now. If an insurance carrier writes a policy that underestimates the cost to rebuild after a fire because they use an algorithm known to be faulty, per an article in today's San Francisco Chronicle, could the HOA sue the insurance company in the event of a loss that dramatically exceeds the covered limit?
This would be an appropriate question for insurance coverage counsel. They would dig into the algorithms used, or whether or not the insurance carrier, or even if it was an insurance broker that was used to come up with the amount. I mean, certainly the insurance company is going to say, yeah, but this is the amount you asked for. But this is a prime example of a situation where I would recommend working with insurance coverage counsel. And these are attorneys who provide advice and counsel, and they also litigate on insurance policies and coverage issues.
Mm-hmm. Good answer. Yeah, but I think you can sue on just about anything, right? That's the
You can sue on about anything, but the question is whether or not you're going to have a real claim.
That's right. That's right. Okay, so Carol Lawrence. Hi, Carol from up here or down here in Southern California. Do most collection companies used by HOAs do a title search before a lien is placed? I think it is expensive in Los Angeles County if you do not have a real estate license, maybe $700 or so. Do
I
you know?
don't know if collection companies, I don't know what their practice is, but I know I do it. And my practice, it's certainly not that expensive if you know the property address, the parcel number, and which county they're in, which obviously if you're the HOA. If you know if you know the parcel number, that search is free. Oh, well, I mean, the search itself is free, but the requesting of the documents is going to be nominal. It's going to be a couple dollars to actually request that document. Again, it depends on the county you're in. Some counties make it much more difficult to pull title, but I know in the Bay Area, nearly all of the counties that I've worked in here and had to do a search, you can pull it by going to the recorder's office website, putting in the APN and seeing what the latest documents are for that APN. Or you can do a search by the grantor grantee list, and in which case you put the name of who you think the owner is, and you see whether or not they sold the property, or if they're still showing up as the latest grantee on that property.
Mm-hmm. Sounds good. Good response. I just refreshed again, and
Okay.
at the top of the list is anonymous attendee. Can reduce quorum, a la AB 2460, the recently passed, be used if governing documents state a quorum and also a reduced quorum if quorum's not met?
So if the governing documents state a quorum, then yes, you can use that 20% reduced quorum. But if there is a reduced quorum that's below 20% and you don't hit that, then it doesn't apply, because then you'd be forcing yourself for the association to go up to the 20% if there's already a further reduced quorum.
Right.
So 20%, unless the governing documents state a lower amount.
Yep. Okay, that makes sense. So here we go again. Melissa, what is the obligation on HOAs to use licensed plumber for common area plumbing issues? Is it required by California law to use the licensed plumber, I guess?
I believe it is required to use a licensed plumber for all plumbing related issues. And if it's not required, I think the HOA has a duty to do that, just from the standpoint of making sure that the work is done properly and for the benefit of the community. Um, Certainly, I know that there are laws that say that anyone who acts as a plumber should have a license. But yes, I mean, from the standpoint of whether or not the HOA has an obligation to use a licensed plumber, uh, if there is not a requirement by law for the HOA to do it, I would imagine there are a number of duties that the HOA and the directors and the managers have to the HOA that it be done properly, and including using a licensed plumber.
Okay, so that's good. Thanks, James, for your comment. Let's see where we go from here. We have anonymous attendee again. Anonymous attendee. Does the board have a responsibility to respond after they investigate? We have a board that did not respond in many cases. Um, and I guess that's for a rules violation, I'm assuming.
Or even just in as part of their duty to investigate.
Yeah.
The steps that a board takes in response to claims, I guess it depends on how far we are in the process. Certainly, the board should very well paper their trail, and if they do something, they should meet in an actual meeting. Could be an executive session if it deals with litigation or potential litigation, but it should be pretty well documented. And if they decide not to do anything, I guess it depends on the issue, whether or not they respond to the homeowner or tenant that made the claim that's being investigated. But certainly they need to document the fact that they heard, considered, and then determined to do something or not do something in relation to and to their investigation.
Okay, thank you. Here's the next question. Again, I refreshed, and this is regarding SB 900. If the utility individual sewer line becomes defective under HOA common area due to the property owner's irresponsible action, who pays for the repair? That seems pretty site specific there.
Seems site specific. Yeah, I think there might be two competing things here. One is the law, SB 900, and but also the property damage that's done by that property owner. So if the property owner does take some action that the association can act upon, that they may want to pursue that. Um, Certainly the repairs should be done, and the HOA might choose to do those repairs, but their decision to seek reimbursement or sue that homeowner is one they can consider as to whether or not they've got enough information to show that that damage and resulting cost was the result of that owner's irresponsible action.
Good, appreciate that. Yeah, they're trying to iron out the issues with SB 900 this year, trying to figure out how they're going to implement. In any case, we have the next question here. How can a board keep its insurance company from providing coverage to an owner when the owner makes modifications to his unit without approval? While he was on the board at the time of the modification, he was not acting in his capacity as a board member. However, he turned it over to the insurance company, and I'm assuming that's for the boards, the community insurance, and they are agreeing to provide coverage to him. So that's pretty specific. So I don't know if you want to tackle that one or not.
It sounds like there's some facts here that are not being shared, and yeah, you're right. It seems pretty fact specific.
Yeah, it's going to be very fact specific. So we can't without getting into it much more. We wouldn't be able to answer the questions so that you could get good information. So we'll pass on that one. Next one, Connor. What is the site to Ninth Circuit course case that defines what an assessment? What's an assessment? And I don't know what that would mean.
I would have to check to see what the case is. I don't know if they define assessments, but I know this. I can provide the site to the case that gets into the fact that the assessments were part of a debt. I will have to check, and anonymous attendee, if you want to send me a message via the chat, I can get back to you on that.
Okay, appreciate it. Okay, so we're getting down to the single. We're not getting a lot of thumbs up here, so I guess we'll move through these rather quickly. They're short questions, and I'm gonna refresh. AB 2660. What if reduced quorum in governing documents is 33%? Can 20% be used instead of the percent stated in the governing documents?
Yes, again.
That's the point of the law.
Yeah, that's part of the law.
Stacy asks if an HOA claims homeowner responsibility for a common area plumbing issue, do they need to provide documentation of why or how the cited CC&Rs apply, or is this the homeowner's responsibility to determine? I hope this is a relevant question for today's
So
topic.
if the HOA, sorry, let me go over that one time. If the HOA claims homeowner responsibility, the level of justification and support that's in any communication is really at the discretion of the HOA as to whether or not they want to provide that. Certainly, if they're in either case, the homeowner might say, no, I don't agree with you. So I think the CC&R should state what the obligation is, and if it doesn't state, especially if it's not going to be as clear. So that's going to be pretty fact dependent, because many times what is common area versus what's part of the unit is dependent on exactly where the issue is, or exactly where the element is, including where it is in relation to the wall. I guess to answer your question, Stacy, no, it doesn't. The HOA does not need to provide documentation, but it depends on how it plans on imposing that obligation. Certainly, if it's going to be imposed as a reimbursement assessment, it has to clarify exactly how what the reimbursement and assessment is based upon. And certainly, I would recommend all HOAs just to be pretty clear and transparent as to what the justification is, just to prevent the back and forth and having to provide that information anyway. But short answer is no, it doesn't have to.
Okay, so I think I'm gonna since these are all mostly single questions, I think I'm going to go ahead and take a couple more if there are multiple if multiple people want the questions asked. I'll take those, but then we'll go ahead and close this down. What about using a general contractor for common area that needs concrete work and plumbing work? Must the general contractor have a plumber's license?
I don't know. Depends on the extent to which they're doing plumbing work. That is going to be a question specific to a business professions code that I would have to look into and to provide that answer.
Right. Okay. And so I'm going to take one more question here. And what about using a general contractor for the common area? Oh, hold on, I missed that. Can management charge interest on full amount of an HOA dues, even if partially paid? And it says, for example, if there's a $24 overdue balance on a $680 amount that originally was overdue, can they charge on the $680, $68 or just
Facially, that doesn't seem right. I would look to what the CCNR say as far as what is imposed for late fees, but that does not seem right to charge significantly more than the amount than the overdue balance versus what the 10% that the $68 ends up being on it. But that's going to depend on what the governing documents say.
Yeah, I think that's an interesting one as we close here. I think that's a really interesting one because they would have a very difficult time defending that if that was challenged. I'm sure, yeah, there might be some situation there. But anyway, let's go ahead and move on. I want to say thank you to Lewis for participating
My
today
pleasure.
and going through all of this. It's not easy to stay up on all of the legislation and the different case laws. So thank you, Lewis, for your help and participation in doing that. I want to thank all of our members for coming today and supporting our ECHO webinars. There were a lot of questions about differences and who's responsible for what. We do have a seminar coming up on June 7th in San Jose that's speaking specifically about that. It's a Saturday in-person event with lunch served. It is available. It's on June 7th from 9:30 until 2:30 in the afternoon. So if you have those specific questions, we have attorneys that are going to be talking about those issues. Thank you to our members. And for those of you who aren't our members, but you attended today, we'd love to have you as a member. It really does help us a lot to build our numbers and be able to bring you even more robust programming. For ECHO members, thank you again. And please invite your friends, board members, your various vendors and management firms to participate. I think they would enjoy it as well. They'll learn a little bit, and that would be nice if we could improve the educational efforts in this community. A simple invitation is usually all it takes to encourage someone to join ECHO. If you would like to become more involved in ECHO, please consider joining our volunteer corporation, our volunteer course. We have a really good group of people that help us out on various different things. Love to have you there. As part of our volunteers, you will have a few opportunities where we could use your help. Please refer to the slide. It's on now. If you see anything that looks interesting, please send me an email at dzappone@echo-ca.org. Or if it's not on that list and you'd like to help out, let me know. We are looking for some authors and editors, and I'm really would like to get more homeowners, board members to write articles about their experiences and get those published to help other homeowners. Now, for our other announcement, the ECHO HOA University has an educational program focused on HOA board preparedness. The core curriculum of 10 courses is designed for high-quality training and is available for HOA board members. Interested homeowners and professionals are welcome to participate. Your participation in this program will earn you a certificate of HOA board preparedness from the ECHO HOA University. It's 29 and a half hours of coursework. So it's a significant amount of work. And I think we cover everything you need to know, at least at the basic level, on about how to run an association. If you have an apathetic community, I would suggest that you bring them along and have them participate. They'll learn. A lot of times their apprehension is because they don't really understand what their rights and responsibilities are. So the courses are offered live, online, and on demand. Most courses are recorded and available on demand, with the exception of two. One is ethics, and the other is the capstone course, which we require that you participate online and in person. If you or someone you know wants to enroll in the certification program, please send them Connor's email address. He's happy to help you with that. And his email address is on the screen now. So it's Connor at echo-ca.org. Connor is spelled with two O's, by the way. We just finished up our second quarter of resource panels, and here is a preview of some of the panels coming up at the end of this summer. Sacramento Resource Panel, the Echo Club at Rossmore, which is run by the community there. East Bay Resource Panel, Thursday, the August 7th. Los Angeles Resource Panel is the 12th. Orange County, those of you down here, is August 13th, and we look forward to seeing you there. The San Diego Resource Panel will be Thursday, August 14th. We also have 3 larger in-person events planned for this year with multiple speakers and 20 or so exhibitors. Registration for our first event is June 7th is available for registration now on the website. We are extended our early bird opportunity for registration. It's free right now, but as of the first of the month, 1st of June, there will be a fee. We have already secured about 135 to 150 people attending. So this is a larger event. It'll be a lot of fun, food and beverage and prizes. So take advantage of the early bird by May 31st. Northern California Educational Seminar is the 7th of June. The Southern California Educational Seminar, which will be similar, is October 10th. And then we have our legislative update and Northern California seminar on November 15th. And that's over at Rossmore and Walnut Creek. That's always a fun one with all the legislation. I want to say thank you once again to Louis for being here and for presenting to us on the current cases. And special personal appreciation for his time. He's been doing this for a while now, and it does take a little bit of extra effort to put it together. So thank you so much, Louis, for your help. And of course, I want to thank all of you for attending today and making this a successful event. Echo appreciates your investment in education to foster a better quality of life in HOA communities.